everyone, my name is Meyven. I'm a lawyer practicing in West Malaysia. Today, I'll be sharing on the rights and remedies available to landlords when they are dealing with tenants who are in default of payment or in any kind of default. And I would like to take this opportunity to thank Star Property for inviting me to share my knowledge with all of you. And also thank you for watching this video. Before we begin, I would like to highlight that this sharing is meant to provide general information on the topic that I'll be sharing, and it may not apply to all jurisdictions such as Sabah and Sarawak. If you are facing any legal issues, I suggest that you seek legal advice. So one of the common breaches by tenants is non-payment of rent to their landlords, or sometimes non-payment of utilities bills to the service providers. Occasional late payment would have been acceptable, but what if the tenants have been in default for months, and despite reminders after these reminders, there's just no indication that they would pay up? Some tenancy agreements provide for late payment interest, where the landlords can impose interest on outstanding rent for the period when the outstanding rent remains unpaid. But this late payment interest does not compel the tenant to pay their rent on time. And what if the landlords do not wish to keep the tenants anymore and then terminate the tenancy agreement, and the tenant refused to deliver up the rented property after the termination? In order to prevent tenant from delaying payment or even utilities bills, and to evict tenants, some landlords have resorted to self-help remedies such as locking up properties, cutting off electricity and water supplies, or re-enter the rented property physically. These are very common self-help remedies. The question is, can the landlord do that? We will look at these remedies in turn. Firstly, locking up the rented properties. Before 31st January 1992, self-help remedy was available to landlords to recover possession of their rented properties without having to go through court proceedings. This is because the old Section 7 of the Special Relief Act 1950, which is shown on the slide, did not make it compulsory for the landlord to go to court to recover possession of their rented properties. This was affirmed in a case of in the Supreme Court, in the case of the trustees of Leong San Tong Ku Kong Si against Po Sui Siang. However, the position is quite different today since the amendment to Section 7 of the Specific Relief Act 1950, which is shown on the slide next. From 31st January 1992 onwards, by virtue of the amendment to Section 7 of the Specific Relief Act 1950, self-help remedy is no longer available to landlords, legally available to landlords, as they can only recover possession of their rented properties from their tenants through court proceedings. The keywords of the provisions are highlighted in bold in the slide. So, as you can see, if these criteria in Section 7 of the Specific Relief Act are met, the property is rented out under a tenancy, the tenancy has ended, the tenant remains in the property, then the landlord cannot resort to self-help remedy, and they must go to court to recover possession of their rented properties. Hence, locking tenant out of rented property has been held to be in breach of Section 7 sub 2 of the Specific Relief Act 1950 by the Malaysian court time and time again. We will look at one of these cases, SME Aerospace, Sdn Bhd against Malaysia Sdn Bhd. In this case, the tenant was in default of rent for the last 2 months of the tenancy agreement and had remained in the premises or the rented property after the tenancy has expired. Slightly more than 2 months after the expiration of the tenancy agreement, the landlord locked up the property, which effectively evicted the tenant from the rented property. The High Court held that although the tenancy has ended, the tenant remains as a tenant, or more precisely, tenant holding over, which means a tenant who remains in the rented property after tenancy agreement has ended. Therefore, under the new Section 7 of the Specific Relief Act 1950, the landlord must obtain a court order to recover possession of the rented property. The High Court also held that the act of locking out the tenant amounts to a tort, which is a wrongful act which will lead to legal liability. In order to safeguard their rights, some landlords have included recovery of possession clauses in their tenancy agreements, where the landlord and tenant agree that the landlord will be entitled to recover possession of the rented property in the event of default by the tenant. This seems like a very clever step. Unfortunately, the court in Noor Islam Worldwide Industries Sdn Bhd against Yi Kot Sam held that even when a tenancy agreement allows the landlord to recover possession, the landlord's action in locking up the property go against the law, which is under Section 7 of the Specific Relief Act. And the entitlement under the tenancy agreement should not override the law. So we are clear that locking up the property is not a self-help remedy permissible by law. Next, we will look at what if the landlord proceeded with the locking up of the premises. In that case, the landlord is in effect dispossesses the tenant of the rented property and does so at his own risk. In fact, under Section 8 of the Specific Relief Act 1950, which is on the slide, provides that a tenant who is dispossessed of the rented property, not through court proceedings, may claim for repossession of the rented property, which is exactly what happened in the case that we looked at earlier. In the case of SME Aerospace Sdn Bhd against Malaysia Sdn Bhd. Having defaulted payment of rent and remain in the rented property after the tenancy agreement has ended, because the landlord did not go through court proceeding to recover the rented property, the court actually allowed the tenant's application to repossess the rented property. This may seem very unfair to the landlord, but Section 7 is enacted to protect the tenants from wrongful eviction. Next, we will look at cutting off electricity or water supplies. It was argued in the case of Tasik Maju Realty Sdn Bhd against Teo Su Wei and another that the act of the landlord in cutting off the electricity supplies is a form of self-help remedy to evict the tenant from the rented property, because the rented property will not be functional without electricity supply. The High Court, however, is of the view that the landlord is entitled to do so because the tenant has agreed to it in the tenancy agreement. Further, the High Court also found that there was no dispossession of the property by the landlord, because there was no removal of the tenant's belongings from the property. But to avoid repercussion, landlords should read their tenancy agreements carefully to find out whether they are entitled to do so under the tenancy agreement. And even if they have the right to cut off electricity supplies or water supplies, I would advise that landlords should abstain themselves from exercising this right under the tenancy agreement, because the consequence which it might bring about may be difficult. This is so even though there is a case decided by court that cutting off supplies is not a self-help remedy. Lastly, we will look at physical re-entry by the landlord. Section 234, subsection 1 of the National Land Code, shown on the slide, provides for forfeiture of tenancy if the tenant, among others, breaches the express or implied provision of the tenancy. In this regard, payment of rent is an important provision of a tenancy, the breach of which would give rise to the landlord the right to forfeit. When the right to forfeit arises, Section 234, subsection 2 of the National Land Code provides that the landlord may exercise his right by re-entering onto the property or by court action. However, Section 234, subsection 3 provides that the landlord will be prevented from doing so if he accepts any rent due or show the intention to continue with the tenancy before the right is exercised. In order to exercise this right to forfeit, there are preconditions that the landlords need to comply with under Section 235 of the National Land Code, namely, the landlords need to serve a written notice on the tenant which states the breach of the tenant and requires the tenant to make good the breach. It is only when the tenant fails to comply with the written notice within a reasonable time the landlord is entitled to exercise his right to forfeit. In the case of HB projects against Investprop Malaysia Sdn Bhd, the Court of Appeal agreed that termination of tenancy agreement in that case should be by re-entry as provided in the tenancy agreement. Nevertheless, the court held that it is best to recover possession of the rented property through court proceedings, as physical re-entry is not desirable if it is opposed by the tenant, and to avoid opposition by tenant as well. Further, the landlord may be subject to claim by tenant under Section 8 of the Specific Relief Act 1950, which we discussed earlier. It is also worth noting that Section 234, subsection 2 of the National Land Code provides that re-entry is subject to the law which is enforced at that time. In other words, re-entry is subject to Section 7, sub 2 of the Specific Relief Act 1950. Hence, physical re-entry is also not advisable. So, having looked at the legality and viability of self-help remedies, I will now share with you the legal remedies available to landlords to recover outstanding rent, outstanding utility bills, or when the tenancy agreement has been terminated, to recover possession of the rented properties and to claim for double rent. There are two main actions that the landlord may take, which are distress action and writ action. We'll first look at distress action. A distress action is an action provided under the Distress Act 1951, which enables landlords to recover outstanding rent by seizing the tenant's belonging found in the rented property. It is applicable during the continuance of the tenancy or even after the expiration of the tenancy agreement, provided that the tenant or when the tenant has abandoned the rented property, his belongings are still within the rented property. The landlord can commence distress action by filing an ex parte originating summons in court for an order for the issue of the warrant of distress. The warrant of distress will be executed by a court bailiff at the rented property, where the tenant's belonging within the property will be seized. After the seizure of the tenant's item in the property, the bailiff will then make an inventory and an approximate valuation of the seized property, and give to the tenant a notice of the seizure with a copy of the inventory and the valuation, informing him the amount which is due under the warrant of distress, and requiring the tenant to pay up the outstanding rent within a prescribed time, failing which the seized items will be sold at a time and place decided by the bailiff. Unless the tenant is able to pay the outstanding rent in time, and also the tenant is able to obtain a restraining order to restrain the sale, otherwise the seized item will be auctioned. If the tenant pays the outstanding rent in time, there will not be a sale of the seized item. However, if the tenant fails to do so, the item seized will be auctioned off, and the proceeds of the sale will first be applied to the bailiff's expenses and costs, and then in satisfaction of the outstanding rent. The balance of the proceeds of the sale will then go back to the tenant. We will now look at the effectiveness of of distress action. And distress action is an ex parte proceeding where the tenant will not be present. The landlord needs not make known the existence of the action to the tenant. In other words, the landlord needs not serve the originating summons on the tenant, since the tenant will not be present. The proceedings are not opposed by the tenant, therefore, the action is meant to be expeditious and cheaper. However, in practice, there may be delay to the action depending on the locality of the court where the distress action is filed, as some courts may have a backdrop of execution. Under a distress action, the landlord can only claim for outstanding rent and not for outstanding utility bills or double rent. For outstanding rent, the landlord can claim up to 12 months of outstanding rent preceding the commencement of the distress action. For example, if the tenant has not been paying rent since January 2019, and the landlord is only taking an action against the tenant in September 2020, the landlord is only able to recover the outstanding rent from October 2019 until September 2020. And there will not be claim for double rent for tenant holding over, because it is only available in writ action, and because it is a penal sum, not a rent due. Also, not all items belong to the tenant in the premises or in the rented property will be seized. The items which are exempted from seizure are the items which the tenants were holding or they are holding during the execution, the clothing and bedding of the tenants and his family, or belonging used by the tenants for his trade and business, so on and so forth. Sometimes the proceeds of sale of the seized item may not be sufficient to cover or to realize the outstanding rent and also the expenses of the execution proceedings. This is quite common, especially when the rented property is fully furnished or partially furnished. We will now look at writ action. A writ action is in a writ action, a landlord can recover outstanding rent, outstanding utilities, or when the tenancy agreement has ended, the tenant remains in the rented property. The landlord may recover possession of the rented property and claim for double rent. A writ action is commenced with the issuance of writ of summons by the court. A writ of summons is a document stating that a claim has been filed against the defendant by the plaintiff and requiring the defendant to respond to the claim. As a writ action is an inter-party proceeding where the court will hear from both parties, the writ of summons will have to be served on the tenant together with the statement of claim, which is a document stating the facts of the matter and also the relief sought by the tenant against the stating the relief sought by the landlord against the tenant, so that the tenant will know the landlord's claim and has the opportunity to respond to it. After hearing from both parties, the court will then grant judgment to the landlord if the landlord succeeds in proving his claim against the tenant. However, in the event the tenant refuses to obey the judgment, the landlord will have to make an ex parte application to the court for permission to issue a writ of execution for the bailiff to compel the tenant to obey the judgment. Modes of execution which are available to the landlords are writ of seizure and sale, garnishee proceedings, writ of possession, committal proceeding. A writ of seizure and sale is quite similar to a distress action, while garnishee proceedings is where the landlord will apply to court to attach the monies due to the tenant by third parties. But this proceeding is only possible if the landlord has knowledge of the tenant's bank account details or debt owed by third party to the tenant. We have looked at recovery of possession extensive earlier. For writ of possession, when a landlord brings an action for possession, he must show that the tenant's right to possession has ended before the commencement of the action. Where the tenancy agreement is not ended by expiration, a notice of quit or a notice terminating the tenancy agreement will have to be given to the tenant. Once a writ of execution is obtained, a court's bailiff will then execute the judgment on behalf of the landlord. So the judgment or order for recovery of possession may also be enforced by committal proceeding, where the tenant is required to deliver possession within a prescribed time, fails, refuses, or neglects to do so. In a committal proceedings, the tenant who is in default of the judgment or order of court may be cited for contempt of court and for disobeying the judgment or order, and may be committed to prison. The advantages of writ action are the landlord can make multiple claims in a suit, and there's no limit as to the amount which the landlord can claim or the reliefs that the landlord can seek in a writ action. And the landlord can choose from multiple modes of execution when the tenant refuses to obey the judgment or order from court. However, as the writ action has to be brought to the tenant's attention, service of the writ of summons and statement of claim is required, and the action may be opposed by the tenant. Hence, the proceedings will most likely be prolonged and more legal costs will be incurred. Irrespective of which remedy the landlord is taking, the landlord will have to incur cost and time, and there's no certainty that the landlord will be able to recover the outstanding rent. I will come to the last issue, which is double rent. If the tenant refuses to deliver possession of the rented property after the tenancy has come to an end, the landlord has the discretion to charge double rent under Section 28 sub 4 paragraph A of the Civil Law Act 1956. The Federal Court in Rojas Assets Sdn Bhd, formerly known as Wisma Perkasa Sdn Bhd against Weatherford Malaysia Sdn Bhd and another, held that the landlord only needs to show that the tenant is holding over after the expiration of the tenancy agreement. Whether a tenant is holding over the rented property, the court looks at whether the landlord has consented to the holding over by the tenant after the expiration of the tenancy, whether expressly or impliedly by conduct. In this case, the landlord did not make its intention clear to the tenants that it did not wish to renew the tenancies and wanted the tenants to give up the possession of the property after the tenancy agreement has ended. Further, the landlord agreed to negotiate for renewal of the tenancies and did not make it clear to the tenants that the tenant can only hold over the rented properties on the condition that they pay double rent. While the negotiations for renewal were ongoing. In fact, the landlord was accepting payment of rent from the tenants without any complaint and did not issue any notice to quit to the tenants until the negotiations for renewal have failed. Therefore, the court ruled that the conduct of the landlord the landlord had waived its right to charge double rent against the tenant. Whatever the circumstances may be, it is always advisable for landlord to constantly monitor the payment of rent by their tenants and also to build a good relationship with them so that they will be able to have knowledge of any default such as damages to the property and so on and so forth. So that the landlords can take prompt action against the tenants when the tenants do not honor their promises under the tenancy agreement. Taking legal action should be the last resort when the tenant refuses to cooperate. I will end my sharing here for today, and I hope you benefit from my sharing today. Thank you for watching.